is Shanna Montgomery. I am a Florida licensed attorney, and this channel you will find all kinds of good information about business law and intellectual property law. So I started my own practice in January officially of this year. So it is relatively new, and I focus my practice on intellectual property, mostly trademark applications and some business stuff. I am licensed in the state of Florida, I think I just mentioned that, and also California, although I have not paid my dues yet, so not officially licensed. I did take and pass the bar in July of this year. So that said, this video, I don't know if you've seen any of my past videos, maybe this is the first one you've seen, whatever. Every single video I have to give my standard disclaimer, and that is that this is not intended to be legal advice. This is simply some legal knowledge that I want to pass along and hopefully help you get started in the right direction if you are a small business or maybe you're a huge business. I don't know what your situation is, but not legal advice. I am not your attorney unless you email me, which the email address will be in the box below, and we decide to work together. All right, so I have a computer set up here with a little bit of notes just in case I need to reference it, so I apologize if I look over. Today's video is going to be all about office actions. In the last few days, I've had some client consults, and I have to kind of go over the office action process with them, and it can be kind of confusing. And so I thought, you know what, let's go ahead and get a YouTube video up, and I'll probably also post an article on my website to kind of go over some of this as well, just so that people have a place to go and they don't have to be confused during my consultations when it comes to office actions. So what are office action? An office action is something that the USPTO will give in response to a patent or trademark application. I'm going to discuss them in the realm of trademarks only. I do not practice patent law, so everything I'm going to say today has to do with trademarks and trademarks only. An office action is going to be a letter from the USPTO in response to your trademark application. And if you hired an attorney to file your trademark application, congratulations, you did the right thing. You might still get an office action, but you're not necessarily going to need to worry about this too much because the attorney is going to know how to handle it. If, however, you decided to file your application on your own or use something like LegalZoom to try to save some money, you are likely going to get an office action, and the LegalZoom, they're not going to help you with it. That's not part of the process. And if you're on your own, I'm just gonna kind of go over what they are and what they mean and give you a few suggestions on what I think you should do. So the office action is just pointing out what an issue with your application might be. There are a few options. It can be something really simple like maybe the specimen that you submitted to the USPTO explaining or showing how the mark is used in commerce wasn't sufficient. Maybe they need something else. Or maybe you're applying for a trademark under an LLC name in a particular state, and the examining attorney couldn't verify that that LLC exists in the state, so they need some clarifications. So those are going to be non-substantive office actions that are really just amendments to your application. Unfortunately, the language that the office action letters use is a lot of legalese, so it can be kind of hard to decipher what it is the USPTO is trying to get you to do, which is why having an attorney on your side can be helpful. But if it's non-substantive, it is a little bit easier to handle, and it's usually just looking for some kind of correction or clarification on your application. The USPTO will also kind of lay out how they want you to respond in their letter. So you really need to make sure that you understand what that letter is asking so that you answer in the appropriate manner, because if you don't, it's not going to be good for your application. The other type of office action you might see is going to be what we call a substantive action. And there are a lot of different types of these. For example, if you try to trademark a name, that's not allowed, so they're going to give you some kind of a refusal on the name. Or if the USPTO wanted you to disclaim something in your mark, like a word that can't be trademarked would be left out, and you would only be able to trademark a certain amount of it. Those are substantive actions. However, the main ones are going to be 2D and 2E office action. A 2D office action is a likelihood of confusion action. A likelihood of confusion action is basically the USPTO saying that there is another mark that is the same or similar to the one you're trying to register, and it is used in relation to goods or services that are the same or similar to what you're trying to register in. And they think that if they allow your mark to gain registration that it's going to cause confusion in the marketplace. So that can be kind of tough to overcome, but we'll get into that in 1 second. And then a 2E office action, which is a descriptiveness action. So for example, let's say you wanted to trademark Bob's Burgers. They might say that's not exactly trademark worthy. It really just describes a guy and what he's selling. It's not arbitrary or fanciful enough to garner registration. So this is the point in the video where I tell you that unfortunately, if you do get a substantive office action, 2D, 2E, something similar, hiring an attorney is probably going to be your best bet for answering that and ensuring that you don't get denied. There's a loud truck over there, so I apologize, but I'm gonna go ahead and just try to speak through this. So if you are dead set on answering these office actions on your own and you want to continue the process by yourself, there are a few things that I want you to keep in mind. So the first thing that you need to keep in mind when deciding to answer an office action is this. Answering a substantive office action is akin to participating in litigation. It's essentially paper litigation, for lack of a better term. So what you have to do is explain to the USPTO, and by explain I mean you have to argue with the USPTO examining attorney that your mark is not confusingly similar or that your mark is not descriptive. And they don't want just your opinion. They don't want you to say why you think it's not confusingly similar, like, oh, there's a difference in this and this and that. Like, they need a legal argument. There are cases, there is precedent, there's a lot of things that attorneys who deal with this regularly know would need to go in that answer that you as an individual might not know. The entire process of getting a trademark registration can be sort of subjective. Each examining attorney has certain steps that they follow, but it is sort of an individual process. So making an argument to an examining attorney on something that you've never had to make an argument before about can be sort of difficult, which is why I say hiring an attorney is going to be your best bet for answering this appropriately and overcoming the hump of a 2D or 2E office action. So just keep in mind that if you don't handle the substantive and even the non-substantive office actions appropriately or properly, then you might risk losing out on your registration. So having an attorney can be really helpful. The second thing I want you to keep in mind is that there is a strict timeline that you need to pay attention to and adhere to. So not only is getting an office action going to change the timeline of your registration as a whole, you also only have 6 months to answer every office action that you get. And if you are trying to formulate some kind of an argument, 6 months might come and go very, very quickly. So just pay attention to that. Again, if you're working with an attorney, that's not something that you're going to have to worry about. That's something they're going to be worrying about and on top of. So keep that in mind. You have 6 months to answer and you need to make sure that you're coming up with the right answer. The next thing, the overall timeline of your application is going to change. So I generally tell my clients that it takes 6 to 8 months from start to finish to get your registration. And if you receive an office action, that's going to extend that even more. And so the longer you wait to answer, the longer it's going to take for you to get that registration. So just keep that in mind. After you get one of these, really either get on finding that attorney or get on writing your answer or submitting your answer. And the last thing that I want you to remember with office actions is there are 2 different kinds. There is non-final and then final. So a non-final office action, it could be substantive or non-substantive, but it is kind of the first chance that you're getting to explain to the USPTO or to make those changes that they are requesting. If you get a non-final office action, that's great. If you get a final office action, that means that they're giving you 1 chance and 1 chance only to fix this issue. And if you fix it incorrectly or fail to fix it, whether that be on time or what they're looking for, then your registration will be denied. So pay attention to what the office action actually says, non-final versus final. If you do get a final office action, I suggest even more so that you should find an attorney to work with and help you answer properly. So I'm going to wrap it up here. I hope you found this helpful. So let's just review the 4 things that I want you to keep in mind. 1, answering an office action is very similar to participating in litigation. So if you're going to do this on your own, make sure that you can prepare a very well thought out and researched legal argument to the examining attorney about why your mark is either, not going to cause a likelihood of confusion or not overly descriptive or what have you. 2, you have 6 months. That's it, 6 months to answer the office action. Once that time is up, then you lose your opportunity. 3, the office action is going to extend the timeline as far as when you're going to get registration. I always say 6 to 8 months, and if you get an office action, it's going to extend it for even longer, so it's in your best interest to answer as soon as possible. And number 4, there is a difference between final and non-final office action, so make sure you pay attention to what your office action actually says. I really hope you found this helpful. If you have questions, please leave a comment below, or if you just have thoughts on the video, leave a comment below. Go ahead and subscribe to my channel and give this video a thumbs up so that more people who are applying for trademarks, whether they're doing it on their own or through LegalZoom or some other company, can see this and hopefully get an idea of what an office action is, because they can be kind of confusing and they can be pretty serious. If you're ready to get an attorney to help you with yours, feel free to email me. The email will be below, like I said earlier. I do provide free 30-minute consultations, and I'd be happy to review your application, see where you're at, and maybe we can work together. So have a great day. Thank you guys for watching, and I will see you in the next video.